Okay, so my brief is on it's the school district of Abington Township versus Schempp, and also Murray versus Curlett. And this case, or these two cases, were actually, the way that I understand it, lumped into one and decided by the Supreme Court of the United States in 1963. So basically, what happens in the first case, Abington versus Schempp, then there was a school in Pennsylvania, and in Pennsylvania they had enacted a law that at the beginning of every day they would read at least 10 verses from the Bible without comment at the opening of each public school on every school day. They did have in there that any kid or any student could be excused from the Bible reading upon written request of the parents. The other case, Murray versus Curlett, took place in Baltimore, and it was a law there that they would either read one chapter from the King James Version of the Bible or start school every day with the Lord's Prayer. So basically have an opening exercises is what it referred to it in the book. Initially they did not have a waiver option, but after the complaints of Mrs. Madeline Murray and her son, they eventually added a waiver to where students could be excused from that with written permission from their parents. So the issues here that are the problems are that the state is requiring a reading of the Bible as part of the curricular activities. And it goes on to kind of talk about that, but the big issue there is that the states are actually using the Bible as part of the curriculum for the students. Now, what the Supreme Court found as they looked at that, it said, reading from the book, it says, these exercises are prescribed as part of the curricular activities of students who are required by law to attend school. They are held in the school buildings under the supervision and with the participation of teachers employed in those schools. And in the first trial for the one in Pennsylvania, then it says that it was found that such an opening exercise is a religious ceremony and was intended by the state to be so. So basically both of the states, or both of the states and the townships in this section, or in this case, admitted to having the Bible reading be part of a religious ceremony. Obviously, upon hearing that, then the Supreme Court immediately ruled against that. And they had an interesting thing that they said right here that I really liked. In their ruling, then they said, in the relationship between man and religion, the state is firmly committed to a position of neutrality. They did reference Zurich versus Clausen in their ruling, but they kind of, this one for them it seemed like it was pretty cut and dry as far as clarification and as far as issues. They based a lot of their decision on the interpretation of the First Amendment as well as the Bill of Rights, and they quoted Madison on that aspect, saying that, this is what they said: it is proper to take alarm at the first experiment on our liberties. So basically, even though this was a small step in the wrong direction, they felt it was definitely something that needed to be addressed. And for those reasons, they lumped the two cases together because they were basically similar. And that's the rundown on the school district of Abington Township versus Schempp and Murray versus Curlett.